So I'm Mark Brown from the city attorney, and I advise the Department of Recreational Parks. The ruling that came out really about 3 weeks ago, it's not even a month yet. I'll do my best. I'm trying to address everybody in the room. The ruling came out on the 21st of October, and we were waiting a year or thereabouts to get this ruling from the federal court. And it's in the case of Dowd and several other pro-per plaintiffs versus the city of Los Angeles. And so, as I mentioned, that ruling was filed just 3 weeks ago. I'm going to, basically my purpose here today is to describe to you what the ruling is and what it does to the situation as it was standing. So I'm going to kind of go through the ruling now and just give you a summary of what the judge ruled. First, the judge granted the city's motion to dismiss a part of the complaint that was alleging that the ban on vending on the boardwalk was unconstitutional on its face. And the court found that since none of the plaintiffs in the case are actually engaged in vending, they're more performers and more vending things that relate to their performances, the judge found that they lacked standing to complain about the constitutionality, the facial constitutionality of the vending ban as being vague as applied to them. So the judge dismissed the part of the complaint, and it's only part of the complaint, but dismissed the part of the complaint that was attacking the part of Section 4215, which says that there's no vending in general, no vending of commercial products or items on the boardwalk. So the judge did not strike that part of the law down. That part of the law still stands.
That part of the law stands?
Hold on, folks. We'll hold questions
Okay.
back in a bit. Sorry about that.
That's all right. Also, the judge granted the city's motion to dismiss the constitutional facial challenge to the council's rules of decorum, and I know that's secondary to the issues of the boardwalk, but that's another part of the judge's ruling in this case. The plaintiff said that the council rules that require them to act in a manner that doesn't disturb the council while it's in session. While they're allowed to exercise their First Amendment rights, they're not allowed to create a situation where the council can't conduct its meeting. The court said that those rules are constitutional, and the court mentioned another city that had adopted similar rules, and the Ninth Circuit had upheld those rules already. So the trial court was bound by the Ninth Circuit's ruling to not overturn the council's rules of decorum. So those are two parts of the judge's decision that went in the city's favor. The plaintiffs did get some changes as a result of the preliminary injunction. And so the motion for preliminary injunction is it's an interim order in the case. It doesn't end the case. It doesn't mean there's not going to be a trial of the case, but it decided certain issues that were brought before the court, and it decided them in a manner that while the case is going on, still this order is in effect. And the reason for the judge doing that is because the judge found that the plaintiffs were likely to prevail on these issues if the case proceeded to trial on these issues. So he's made certain rulings about the case while the case is still going on. And one of the rulings that he made involved amplified sound on the boardwalk. The city had set aside 56 spaces out of what the court said is 205 spaces. And I think that's approximately right, but I think there's actually 210 spaces. But the city had set aside, according to the court's ruling, 56 spaces to be used for amplified sound in certain designated space locations. And the court found that that meant that 149 spaces were totally banned from using amplified sound. And the court analyzed the city's regulation that allowed amplified sound in 56 spaces. The court analyzed that part of 4215 as being a ban on amplified sound on the boardwalk. And what the court found is that a ban on amplified sound is not a narrowly tailored remedy to achieve the city's interest or to achieve a substantial governmental interest, which is required when you're attempting to regulate, or when a governmental body is attempting to regulate expressive activity in a First Amendment forum. So, in finding that it was not narrowly tailored, the effect of that is that anywhere on the boardwalk now, amplified sound may be used. This doesn't mean that amplified sound can exceed the city's other noise laws, or that it can, it doesn't mean that there's no laws in effect that relate to amplified sound. That's what I'm trying to say. And what it does do is it allows for the city to enforce any other noise laws that apply anywhere else in the city in a similar situation. And also, there's a part of 4215 that applies not just to the boardwalk, but also to the adjacent private properties on the boardwalk, which controls the decibel level of sound. And the court did not throw that out. So it's still open to enforce noise ordinances, and particularly the part of the 4215 that regulated the decibel level of sound on the boardwalk. So those are still in effect and remain in effect. The judge's ruling didn't touch those. And the last thing, not the last thing, but another thing that the court ruled in favor of the plaintiffs on is, and this is kind of, I think, the heart of the matter for a lot of the people here, is the judge ruled that the permit and lottery system was unconstitutional on its face, and he's enjoined the city from issuing permits, and as a result of that, holding the lottery to assign the designated spaces. Now, the city is still going to have the designated spaces, and what the court said is that the court helped the city come to a decision to institute a method of designating the spaces, creating the I zones and the P zones, and the court agreed at the time that the city enacted its law in 2008 that a lottery system and a permit system would be an effective way, and he thought, the judge thought, a constitutional way of creating some order that would allow the spaces to be assigned in an appropriate way. But after the city adopted its law in 2008, the Ninth Circuit came down with another ruling in another case, a Seattle case called Berger versus City of Seattle. And in Berger versus City of Seattle, the court expressed, the Court of Appeal, Ninth Circuit Court of Appeal expressed some reservations and some concerns about a permitting system that's a little bit different from the one that we have, but the trial judge in this case found that it was close enough that we still were likely to lose a trial on the issue of our permitting system. And as a result of that, the city, he enjoined the city from having a permit system on the boardwalk. So what that means is a few things. It means that no longer is anybody who wants to use a designated space in the I zone or the P zone going to be required to first obtain a permit. It means, in fact, that permits that have been obtained in the past are not, they're really not going to have any meaning or purpose anymore, because there will no longer be a permit system on the boardwalk.